The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Please be seated. Welcome to the Fourth Circuit. We'll hear argument in our first case. The judges are here, but the lawyers are on television. So that'll be Salgado versus Garland. Mr. Valera.
Good morning, Your Honor.
Yeah, you can proceed whenever you're ready.
Yes, Your Honor. Thank you. May it please the court. It is my distinct honor, Your Honor, and privilege to appear before you today to present my oral arguments in this case once again. And I want to express my deep appreciation for the opportunity and thank you for your time and attention. Your Honor, let me start first with the issue of jurisdiction and the timeliness of petition for review. Respondent raises at the outset the issue of jurisdiction by questioning the timeliness of the filing of the petition. The respondent argues the 30-day prescriptive period should be reckoned from the December 21, 2020 decision of the BIA affirming the decision of the IJ, but remanding the case back for consideration of voluntary departure to the immigration judge. And that consequently, the petition for review filed on August 10, 2021 was filed out of time. Petitioner, on the other hand, insists it should be reckoned from the July 12, 2021 decision on remand, granting voluntary departure, and consequently said August 10, 2021, therefore petition was timely filed. Now, clearly the 8 U.S.C. 1252b1 and INA 242b1, the petition for review must be filed not later than 30 days after the date of the final order of removal. The issue that then, Your Honor, turns on whether the December 21, 2020 decision of the BIA is final order of removal appealable to the Court of Appeals. Now, the respondent cites here 4 circuit cases in support of its claim that the December 21, 2020 is the final order of removal, notwithstanding the order of remand for consideration of voluntary departure, namely the King-Yuli versus Holder decided in 2011, Perez Vargas versus Gonzalez decided in 2007 by this honorable court, Saldariaga versus Gonzalez cited by this case honorable court in 2005. But I cannot help, Your Honor, but note that the irony that in these cases where the petitioner appealed within 30 days of the BIA decision, the government argued that the court has no jurisdiction because there was an order of remand. Now,
Counsel, could I stop you there and talk about the cases, at least one of them? And I appreciate your argument about, arguably inconsistent positions. But given our decision in the Lee case that said we did have jurisdiction when there was a petition for review of an order of removal where I know the facts are different based on what had occurred there. How does Lee not determine this case by saying that we have jurisdiction when there's a voluntary removal issue pending? If we have jurisdiction under Lee, how does that not make your filing untimely?
If you look at the decision in King-Yuli, Your Honor, it relies upon the footnotes in Perez Vargas and Saldariaga, where the jurisdictional issue raised by the voluntary departure remand were not fully discussed. Now, in that Saldariaga case, the government argued that there was no final order of removal under 8 U.S.C., where the BIA ordered removal, but remanded the IJ to allow the petitioner an opportunity to apply for voluntary departure. And then, of course,
under the Lee decision, in that case, the petitioner had filed a timely petition.
They filed within the 30 days. And here
Yes,
that did not happen in this case. So the court there, and in a related decision that's not exactly on point, but analogous, Mahmoud, it seems like to me that the 30 days is fixed by statute, and your client didn't comply with the statute. And so I don't see quite how we have jurisdiction.
Now, on the issue, Your Honor, if you look at the decision of the Supreme Court on 40 versus INS, which said that the issue on the context of the denial of a discretionary relief, it can be hardly be contended that the meaning of the phrase finals of the final order of deportation is so clear and unambiguous and susceptible only of narrow interpretation. Now, what is clear here, Your Honor, is that the voluntary departure as an ancillary discretionary relief is included in the final orders of the deportation as construed in the aforementioned case of 40 versus INS. Now, for which this is the Supreme Court case, and it should be prevailing over the cited case of Perez versus Saldarriaga. Now, the main question, Your Honor, here is what really is the final order? So it would seem that under the provisions of HCFR 1242.26, except that an alien granted the privilege of voluntary departure under HCFR will not be deemed to have departed under an order of removal if the alien departs the United States no later than 30 days following the filing of petition for review. Now, this provision, Your Honor, recognizes
but if we had jurisdiction, if we had jurisdiction in Lee where there was a timely filing, why do we have jurisdiction here when it was untimely? And the statute seems to be mandatory that it has to be filed within the 30 days.
That's the reason why, Your Honor, that this decision, in fact, in the case of Lee, it even recognized the DADA and the new voluntary departure regulation, which modify the landscape governing voluntary departure. In fact, Your Honor, the Lee case is an authority even that can be cited where a remand of voluntary departure to the immigration court, the Court of Appeals will prudentially decline jurisdiction without prejudice to later ability to file review of the issues raised in the BIA's order should that be her choice after receiving the new voluntary departure order, Your Honor. So,
yes, counsel, I mean, I think that's right. I mean, if there was a filing here within 30 days of the December BIA decision, we would, and voluntary departure was an issue, that does present, potentially a practical dilemma for a petitioner. And I think courts have looked at that in different ways. The Lee court, as you mentioned, from a providential standpoint or prudential standpoint, decided not to exercise jurisdiction, and other courts have stayed cases. So there's mechanisms, if you will, to deal with that. But kind of back to the question, I'm just, if Lee remains good law here, that we had jurisdiction in that case, I'm trying hard to see how that doesn't effectively determine our jurisdiction case here, even though I get, the factual scenario is different.
well, the reason for that, Your Honor, when they cited the case of Perez Vargas and Saldarriaga, they were decided before the promulgation and January 20, 2009 effectivity date of HCFR 1240.26 on voluntary departure. And according to one of the new provisions under HCFR 1240.26, which I quoted earlier, that this is a recognition, particularly the issue that except that an alien granted the privilege of voluntary departure under HCFR 1240.26C will not be deemed to have departed under an order of removal if the alien departs the United States no later than 30 days, which means that an explicit recognition that the respondent's right and is given an opportunity to file that petition for review even after a grant of voluntary departure, which further shows, Your Honor, that the IJ's order on remand, granting or denying a voluntary departure is the final decision, not the BIA decision. Now, notably, Your Honor, in the Queen Yuli case, for example, the government itself urged this court to reconsider its holdings in Saldarriaga and Perez Vargas in the light of the intervening legal developments, specifically the Supreme Court's decision in Dada versus Mukasey and the promulgation of HCFR 1240.26. So here, Your Honor, in King Yuli case, it says that we recognize, as did the Hakim and Giraldo courts, that Dada and the new voluntary departure regulation modified the landscape governing voluntary departure, which means, Your Honor, that given the foregoing, the Perez Vargas and Saldarriaga should be revisited, especially in the light of the Supreme Court's pronouncement in 40 case that bifurcation of judicial review of deportation proceeding is not only inconvenient, but it is clearly undesirable and not the necessary resort from fair interpretation of the pertinent statutory language. So that is a Supreme Court decision. So, Your Honor, clearly here, the main issue here is when the BIA remanded the case to the immigration judge for voluntary departure, there is not yet any final order of removal. And what triggered that appeal to the Court of Appeals, after they grant the voluntary departure, then all the issues being raised here, Your Honor, can now be decided jurisdictionally by this honorable court.
Counsel, can I just ask you, I guess it's sort of a practical question. I mean, you seem to effectively be arguing that Lee was wrong and that this is not really a final order of removal because it's going back on voluntary departure. But a final order, an order of removal, if I'm remembering right, can either be an order of the IJ that orders removal or an order of the IJ that deems the petitioner removable. This is someone who is removable. And I don't see how the order doesn't do that, even if it's going back on voluntary departure.
Well, the reason for that, Your Honor, by its nature, voluntary departure as a form of discretionary reliefs that avoids certain statutory penalties and allows certain favored aliens, like the petitioner here, even before the conclusion of removal proceedings or after being found deportable, to leave the country willingly, among others. So in other words, voluntary departure under 8 U.S.C. 1229C, parens A, paragraph 1, is a statutory provided relief, which the Attorney General may permit an alien to depart at the expense in lieu of being subject to what they call as a final order of removal. So hence, the voluntary departure as an ancillary discretionary relief, as I've indicated, is included in that phrase of the final orders of deportation, as the same is construed in the case of, in the decided case of 40 versus INS.
So just so I understand your position. So you're saying that if a non-citizen gets relief in the form of voluntary departure, that means that is inconsistent with being removable, then that person is no longer removable.
In a sense, Your Honor, because a voluntary departure is one of the recognizes discretionary relief by our law.
But you're a removable person who has been offered this discretionary relief. But your position is that those are two sort of mutually exclusive things. You can't,
yes, Your Honor,
be removable and get, okay.
In fact, Your Honor, if I may, if a person...
Counsel, let me ask you just to make sure I understand your response to Judge Harris's question. Is it your position then that when the discretionary relief of voluntary departure is granted, that at that point, the alien is no longer under an order of removal?
Your Honor, if a person has
That
been
would seem to
granted,
say that they're free to stay in the United States at that point.
at that point where there is a voluntary order of removal, Your Honor, that person is given that time to leave within that particular date of voluntary departure. However, voluntary departure period. However, the moment the case is elevated to this court for petition for review, then that voluntary departure is automatically terminated, which means that with that automatic termination of the voluntary departure, which means that the petition for review, which this court has jurisdiction, needs to continue despite the automatic what you call automatic departure pertaining to the final order of removal because of the conversion, automatic conversion, the moment you file a petition for review.
All right, counsel, do you have anything else for us at this time? You do have some rebuttal time.
So in other words, Your Honor, what is important here as well is if ever this court exercised jurisdiction, again, we wanted this court to look at the relief of cancellation of removal consistent with the decision of Gonzalez-Garland versus Garland, Fourth Circuit decision of 2021, where it says that immigration judge determination whether an applicant has satisfied the statutory requirement of exceptional and extremely unusual hardship to establish eligibility for cancellation of removal presents a mixed question of law and fact subject to this judicial review. Now, in this case, Your Honor, it is clear at the outset that what the BIA did was it adopted and outright dismissed financial hardship out as a ground for exceptional and extremely unusual hardship, which based on the ruling of this court, that the board's decision may be overturned if there is an abuse discretion, and it's abuse discretion if it fails to offer a reasoned explanation for its decision. And therefore, in this case, Your Honor, because it is a mixed question of facts and law, then obviously the court should have test the threshold of exceptional hardship, considering that the respondent is the primary source of finance support for its daughter and financial hardship, as indicated, although is insufficient to demonstrate exceptional and extremely hardship. It was arbitrary because what is involved is not simply a diminution of economic benefits, but rather the total loss of the economic means of sustenance and support that goes to the very survival of the petitioner's 6-year-old U.S. citizen daughter. And it goes against the matter of Resinas regarding the grant of cancellation of removal on the inability of a single mother to provide support for her 6 children. Although in the Resinas case, there are 6 children, the main issue there is not the number of children, but really what matters is the capability to provide financial support. And likewise, Your Honor,
Counsel, your initial time has expired, but you do have some rebuttal time. So we'll hear from you on rebuttal. Mr. Lawrence, we'll be glad to hear from you now.
Good morning. May it please the court. My name is Jesse Lorenz, and I represent the Attorney General of the United States. This court should dismiss or alternatively deny this petition for review. This court should dismiss this petition for review for lack of jurisdiction because it was untimely filed, as Mr. Rodriguez did not file it within 30 days of the board's December 21st, 2020 decision. The government believes that this case is controlled by this court's decision in Lee, where this court considered this circumstance and concluded that the board's order addressing all the other forms of relief, but remanding for voluntary departure is immediately appealable as a final order of removal. The circumstance here is similar. The case on December 21st was dispositive of his cancellation of removal application and of the order of removal, remanded solely for voluntary departure. So for that reason, this case should be dismissed, consistent with Lee. I think that decision is underlined by recent Supreme Court decisions in Nasrallah and Guzman Chavez. In those decisions, the Supreme Court held that a decision on withholding of removal and a decision on cat protection do not constitute final orders of removal where removability had been previously established. I think the important thing to note here is that the fact of removal was established definitively on December 21st, 2020, and that's when the 30-day clock for filing a petition for review ran. The fact that it was remanded for voluntary departure under this court's decision in Lee does not impact the finality of that order.
Counsel, Judge Quattlebaum has a question.
Sure, I'm sorry, and we only see one judge on the panel, so I apologize for that.
Okay, no worries. So I think I understand your argument. In a situation like this, had Mr. Rodriguez appealed, in some ways it puts a petitioner in a dilemma in terms of the relief that is available under statute and that has been sought and might be available. What's your position about the conundrum one might be in terms of appealing a removability decision when there is a opportunity for statutory relief such as voluntary departure?
Sure. Well, Your Honor, I think it's important to note that, under the statute, the order is appealable when a final order of removal on the removability issue is entered, and that was December 21st here under the statute. Then he had 30 days. As for voluntary departure, I think what happened in Lee is consistent with the government's position that the non-citizen would have to file a protective petition for review, if you will, at that time to protect the 30-day period. Otherwise, under the statute, and that's a filing deadline that's mandatory and jurisdictional under Supreme Court law. So you'd have to file something at that point in time. That he didn't. That's not really consistent with the statute. Now, whether this court would have prudentially dismissed at that time, that prudential decision cannot impact the finality of his order, which was final on December 21st, 2020. As to what, I don't know. I can't. I don't.
Counsel, in order for us and Lee to have made the prudential decision to defer, we first had to have jurisdiction.
Right. And that's the jurisdiction attached at that point in time. And the prudential nature of this court's actions can't disrupt that statutory filing deadline, which, as the Supreme Court has held, is mandatory and jurisdictional. Like I said, I don't think the statute contemplates a mechanism for these situations where it's remanded for VD or voluntary departure, but I think it's clear that when removability has been established, the fact of removability, that's when the PFR has to be filed. And here that was December 21st, 2020. The remand for voluntary departure does not impact removability. It maybe changes how he's removed, but that's a little bit different than the fact of removability, which was definitively established on December 21st, 2020.
So what's the effect of that? I mean, as we did in Lee, we could decline to exercise our jurisdiction on a prudential basis. So, and a court could stay the case. Presumably, I've seen that done. If
Sure.
A court doesn't do that, does that effectively nullify the petitioner's ability to obtain voluntary departure?
Well, I don't think so, Your Honor, because if voluntary departure is later granted, I think that non-citizen would be able to rescind his petition for review if he intended to go forward with voluntary departure.
But
I mean, I think
sorry, I thought in the hypothetical we're in, and I don't want to, so what if someone like this, a hypothetical person did appeal within 30 days and we heard the case and decided the case? I thought your position then was that's it. You don't get voluntary departure anymore because the statute puts you to a choice. You have to pick one or the other, and we gave you the review, so you're out on voluntary departure.
well, I'd like to note that that's not what happened here.
I know, but we're trying to figure out what is going to happen.
Right.
We adopt your proposal, your position, then what happens?
Sure. Well, I mean, I think as a practical matter, that's very unlikely to occur that the court would hear the entire thing. Secondly, I would know.
Can I ask you why not? Because you suggest in your brief that in a case like that, this case is distinguishable from Lee. Because in this case, it's not clear that the petitioner is actually eligible for voluntary departure. So maybe we wouldn't exercise our prudential discretion in the same way. In a case like this, maybe we would go ahead and hear the case.
Sure. Well, I don't really know if the statute or your case law provides an answer for that.
What's the government's position? I mean, you suggest in the red brief that this case is different because it's not clear that this non-citizen is eligible for voluntary departure. So maybe this case is different from Lee and we wouldn't exercise our discretion to dismiss.
Sure.
What is the government's position? What should we do in a case like that?
Well, in this case, I think that the court should dismiss because it wasn't filed.
In a hypothetical case where someone just like this, who is not obviously eligible for voluntary departure, goes ahead and files an appeal within 30 days from the removability determination. Should we exercise our prudential discretion not to hear the case, or should we hear the case?
Well, I think that would be, I would think that would be on the non-citizen. That would be his choice to determine whether he wishes to continue or to wait for a voluntary departure order.
So we should hear the case?
I'm sorry, I didn't catch that.
I'm sorry, does that mean we should hear the case because he made the choice and he filed his appeal?
I don't, in that specific circumstance, I think that would be kind of on the non-citizen. That would be a choice that they'd have to make at that time if they wanted to ask this court to abate or to stay the petition for review while voluntary departure was pending. I mean, I agree. I think it would be a waste of resources to go forward if the alien ultimately decides to go forward with voluntary departure. But I don't, that's not the case here. I think that the fact that he didn't file a petition for review within 30 days of December 21st, 2020 takes away all of that kind of decision making, because under the statute, he was required to file within that 30-day period of time. And that's
in the case that we're hypothetically talking about now, which
yes.
is not your case. We all recognize that.
Right.
If there was a timely filing of the order on removal, and unlike in Lee, there was not an assurance of voluntary departure, is it your view in that case that it would be up to the alien to determine whether to ask for a stay, which the court may or may not grant,
Right.
and try to get the voluntary departure order entered?
Well, I guess what I'm suggesting in that case, there's nothing affording this court jurisdiction after the voluntary departure issue is resolved. I don't think there's anything in the statute or this court's case law that would allow jurisdiction at that point in time. I mean, the statute is clear that it has to be 30 days within the time that removal is decided. So I don't quite know where.
We'll assume that the alien files on time.
Right.
And he or she's asked for a stay, the stay's granted. They get an order of voluntary departure. They leave. What do we do with the appeal of the order of removal?
I mean, I think at that time it would be moot because they've decided to depart.
So we would just dismiss it in that circumstance as moot?
I don't see how you could continue to pursue that once you've voluntarily left the country. And I could be wrong here. But I believe that when you accept voluntary departure, you're giving up your other applications for relief. So I believe that would be the case, but
Right.
I don't know if I don't know if that's 100% correct, but that's my understanding of voluntary departure.
And counsel, what if all the same facts, except this time the petitioner doesn't get voluntary departure? It's deemed ineligible for voluntary departure, but he's got his appeal
Right.
theoretically stayed with us, then what?
Well, then I think, then it would be on the non-citizen to decide if he wanted to continue that appeal. Obviously, if he's denied voluntary departure, that doesn't impact the other portion of his removal order.
And if
So
we
yeah,
stayed it and instead we had done what we did in Lee, where we dismissed it without prejudice, then is it
Sure.
still the government's position that he could come back to us then? Maybe the BIA would have to issue a new order or something, but we could get it back before us then?
Yeah, and I mean, I think that's the point of the prudential jurisdiction, where you all dismissed without prejudice for him renewing it after voluntary departure was over. The government wouldn't oppose, the continuation of that procedure. And I mean, that's been in place since 2011. So yeah, I think that would be something that we would be fine with at that point in time.
So I acknowledge we've taken a detour here kind of in the academic field, but I assume the bottom line of your case is petition was filed late, case is over, no jurisdiction.
Yes, Your Honor, and that is consistent with the statute, and that is consistent with more recent Supreme Court decisions in Nasrallah and Guzman Chavez, and also that is consistent with this court's decision in Lee. I know Lee is kind of backwards, flips the facts from this, but at the end of the day, this court determined that even where there's a remand for voluntary departure, the order remanding, which disposes of all the other issues, is immediately appealable. So it has to be filed within that 30-day period. Under other Supreme Court's decision, Stone via INS, that filing deadline is mandatory and jurisdictional. It cannot be tolled. So it has to be filed within 30 days. In this case, it was not. This court therefore really has no other recourse except to dismiss the petition for review.
All right. Anything else you want to tell us, Mr. Lorenz?
No. As to the cancellation application, this court's decision in Galvez Gonzalez gives this court jurisdiction to review mixed questions of fact and law. Here, it's the government's position that Mr. Rodriguez just wants to challenge the weighing of the facts, something that this court still lacks jurisdiction to do. So for the cancellation issue, we'd also argue that this court shouldn't review that determination. Also, that determination consider all of the hardship factors cumulatively. Financial hardship was considered in this case, along with emotional hardship. Those factors were thoroughly and thoughtfully considered. And for this reason, this court, if it does exercise jurisdiction, although we don't think it should alternatively deny the petition. And with that, I have nothing further, Your Honors, unless there's more questions.
All right. Thank you very much, Mr. Lorenz. Mr.
Thank you.
You have some time on rebuttal. Mr. Valera, you're on mute right now, so hit another button.
Thank you, Your Honors. I think the main issue remains that the petition for review must be filed not later than 30 days after the date of the final order of removal. Now, in this instance, Your Honor, there is no final order of removal. What the BIA did was remanded the case to the immigration judge for the voluntary departure, in which case, when the immigration judge granted the voluntary departure, that triggered that alternate issue within which whether the respondent will take the voluntary departure or not, and therefore it is timely filed with the Fourth Circuit Court of Appeals. Now, the context is, again, in the nature of what is voluntary departure. Voluntary departure is a discretionary relief. It is an ancillary discretionary relief included in the phrase of the final orders of deportation. Again, citing that case of 40, indicating that bifurcation, once again, of judicial review of deportation proceedings is not only inconvenient, but it is clearly undesirable and not the necessary result from a fair interpretation of a pertinent statutory language. Now, likewise, considering that since the grant of voluntary departure is terminated by the filing of a petition for review, the alien will be subject to the alternate order of removal, but the penalties for failure to depart voluntarily under this section shall not apply to an alien who files a petition for review and who remains in the U.S. while this petition for review is pending. In which case, again, the decision on Lee is the authority also for the rule that in these instances of remand of voluntary departure relief to the immigration court, the Court of Appeals will prudentially decline jurisdiction without prejudice to later ability to file review of the issues should that choice after receiving the new voluntary departure date. So hence, this was timely filed for purposes of jurisdiction.
All right, thank you, Mr. Valero. We appreciate the arguments of both counsel. Since you're remote, we can't come down and greet you in person today, but I want you to know we appreciate your efforts here and look forward to your returning in person and joining us in the future. So with that, we will move on to our next case, Klein versus Campbell. Kinzel, we're ready to hear from you whenever you're ready.
Good morning, Your Honor. May it please the court. My name is Jim Kinsel, and I represent the appellants Stanley Campbell and Eagle Force Associates, Inc. Your Honor, we're here for three purposes today. One is the appeal of the district court's granting a summary judgment in favor of the appellees. Two, appealing the denial of summary judgment in favor of the appellants. And three, that the district court properly found when interest should begin to run at the trial. Now, on the standard of review, of course, the court knows that it is a de novo review standard for the summary judgment decisions, and it is abuse of discretion for the factual determinations made by the district court. And of course, the court is also well-versed with summary judgment rule 56, but that requires no genuine dispute as to any material fact, and any declaration must be based upon personal knowledge of facts that could be admissible at trial. And of course, that's one of the issues here, is that there is an extremely lengthy declaration used to support the summary judgment motion, where there was facts by the lawyer saying what the oral agreement was that would not otherwise be admissible. Now, there is multiple counts, three of which were at the summary judgment, counts 1, 2, and 3. One is on the written promissory note. I should say count 2 was the breach of the written alleged contract, and counts 1 and 3 are various versions of a breach of contractual promise to pay, subsequently modified note.
So, counsel, can I, I'm sorry to interrupt you so early, but there are a lot of issues and I'm just trying to get a couple things clarified at the outset. One, just hypothetically, assume we agree that there's some issues of material fact that need to be addressed. As I understand it, there's no demand for a jury trial. And I guess my practical question is whether the record that exists now is effectively that record on which a non-jury trial would take place, or would it be contemplated that there'd be a trial when you go through a trial like any non-jury trial and put up witnesses, and there might be more than what's in the record.
Well, there could be more, there could be less, Your Honor. I mean, it's substantially different to ask somebody to prove a case through admissible evidence versus I could tell you what the agreement was or what I think the agreement was. The lawyer on the other side could tell you what the agreement may be.
So your position is you'd go back and have a trial and make all the decisions you'd make in a normal case about what to put on and what to defend and all that sort of stuff.
That's right, Your Honor, because there's choices to be made. And one of the issues here is the concept of fighting Jello. And so the changes that happened with their position of when did this oral agreement take place? Did it take place right when
Well,
the
in fairness, counsel, you could say that to both sides.
with the inconsistent positions or fighting Jello?
Well, to me, they're pretty much the same thing. I mean, you look at what transpired in the Delaware proceedings, and it's almost the polar opposite of what the parties say in this proceeding.
Well, there's two aspects of that, Your Honor. One is the fighting Jello aspect, and one is the inconsistent positions, because what we have tried to do throughout the district court proceedings is trying to, and it just goes back to that basic trial ad law school concept of you got a bunch of facts. How do you deal and tell something that makes sense with all the different facts? And that's what we've tried to do. We haven't tried to, in the district court proceedings, weave and bob back and forth. They have a claim for multiple concepts. And those concepts, there's little tweaks to it on their claim is, did the oral promise take place right before the note was signed, right when the note was signed, right after the note was signed? And what is the effect of that on various defenses that we have, like the statute of limitations, statute of frauds?
In view of our time constraints, why don't we start with what I would think would be the most directly answerable of the claims for liability here. Why isn't the note valid on its face, at least as to the maker associates?
Well, one of the problems with the note, and I understand it's a great question. There's a written note.
We're looking for a great answer.
Well, I'll give you one. And you don't even need me to answer the question. You just have to look at what the plaintiff said. So after the note was signed, immediately after an email was sent by Mr. Campbell, long after the note was signed, Mr. K himself, who is now deceased, described the transactions as never a loan. So he decided it was never a loan. He writes in the email that the concept that this was a loan is totally untrue, misleading. Money has never been a loan. You know that as well as everyone. Now, everyone doesn't include his financial advisor, apparently, and everyone doesn't include all the lawyers that were involved in the case too. But Mr. K said that it's totally untrue. And the very concept, Mr. Klein, who is the personal representative of the estate, he was worried that Mr. Campbell himself during the Delaware trial was putting $2,000 into account as a subterfuge, ridiculed the concept that a note even existed. And he testified that the concept of a note, he was worried that it was not genuine, worried about planting evidence that didn't even exist.
I mean, I read that testimony, but I mean, normally if you sign a note and it's in writing and, I say I have a note, and I say it's in writing, and then later I say, look, I never intended to repay that. I mean, I'd get laughed at for that sort of position. I mean, just because the someone said, there's testimony after the fact. I have a hard time how we get away from, at least on the note, what's in print on the document.
Right. I understand the concern there, Your Honor. But again, we have to look at the standard that we're dealing with on a summary judgment motion. And when the facts are put in the most favorable light, which is the standard that this court is reviewing, the most favorable light, if you put into the testimony that the note was not genuine, that's the most favorable light. We have a disingenuous note, that it is a subterfuge, that is totally untrue. The note is totally untrue. The note is misleading.
What about your client's testimony at the Delaware proceeding? is it your testimony that you agreed to be personally liable on a promissory note for at least part of the money that was coming to Mr. K? Yes. And the note shows up on the various accounts payable ledgers of associates and Mr. Campbell. I mean, what you're saying that this is enough to invoke the parole evidence rule for summary judgment purposes?
Well, those statements happen long after the note. And so
were the ones that you just talked about from Mr. K.
well, I'm talking about the parole evidence rule specifically. The parole evidence rule is usually preventing prior statements from affecting the note. We're talking about statements long afterwards, but to get to the question of how do we deal with that evidence, that testimony at trial? Remember, when that question was asked at trial, the note was not in front of Mr. Campbell. So he is testifying off of memory about how he signed that note. And the other side caught the error and they put Mr. Offit, which is Mr. K's attorney, the deal attorney, the same law firm, the litigation lawyers put the deal attorney on to say, no, Mr. Campbell was wrong. He did not sign it in his individual capacity. He signed it under the entity, Eagle Force's capacity. And when you look at what they cite in their own case on the interest side.
Well, if the testimony was that Mr. Campbell signed the associate's note in his capacity as an officer or authorized party on behalf of associates, how does that allow associates to walk away from the note that's before us?
The other side's testimony was that he signed it in his corporate capacity, company capacity. Mr. Campbell's testimony was mistaken on how he signed it. And then the other side came up, but
right. I understand that. All that may end up being a jury question or a bench trial question, but my original question went to why is associates not liable on this note?
For a couple of reasons, Your Honor. One, they denied the existence of that note. Two, when you look at the transactions that were, and again, this goes back and forth.
So they deny it now. What about in the Delaware litigation?
Pardon me?
I said they deny it now. What about during the Delaware litigation?
During the Delaware litigation, well, it goes back to there was some inconsistent positions that, again, will have to be dealt with by the district court. But both sides, as the court pointed out, and I mean, I can't sugarcoat that there's evidence that goes against us here. And I understand that. And that's what I said during the summary judgment argument, that there is evidence that goes against us and there's evidence that favors us. But that's the point of a trial. At trial, perhaps the district court will find the note to be enforceable.
Counsel, again, just hypothetically, I know you're asking that we vacate and remand on counts 1, 2, and 3. What about counts 4? I mean, even if there's some lack of certainty about an oral contract or an oral modification, wouldn't the statements by your client that are in the record at least create a question of fact of liability on the equitable claims?
Well, procedurally, Your Honor, they did not go forward with count 4 at trial. They were granted summary judgments on 1, 2, and 3, and they had a full trial scheduled and they did not go forward on count 4. So I don't think they can revive count 4 at this point.
So has count 4 been, I thought you wanted a trial. I thought, and you don't, make sure I'm understanding that. So when you say there was a trial, I thought we were here on the review of summary judgment motions.
We're here on the summary judgment motions,
right?
And they did a cross appeal on the court's finding of interest. So
right.
there was a trial. They were granted summary judgments on counts 1 through 3, and they elected not to go forward for count 4 at that trial.
What?
So what was the trial about? Was that just for interest?
There was a trial on interest as well as the concept of attorney's fees and how there should be an attorney's fee, how the attorney's fees should be interpreted. There has not yet been a ruling.
That's attorney's fees under the note?
Under the note, yes, Your Honor.
All right, so that was a bench trial to determine when the interest started to run and whether or not there were attorney's fees under the note.
Correct, Your
And
Honor.
that's the only thing that went to trial.
It's the only thing that went to trial, and then there was post-trial briefings on the reasonableness of attorney's fees, and those have been held in abeyance pending the court's review.
How would you go forward on count 4 in the middle of that trial? I don't understand. I thought the equitable relief and the contractual relief, that was sort of mutually exclusive. So having prevailed on contractual relief, like, why would you go? I don't understand your theory that count 4 has somehow been waived. But I want to give you a chance to explain it to me.
Well, I think it's like any trial proceeding. If you go forward at
But there was
trial,
no trial on liability. It's a theory of liability, and there was no trial on liability. So in what trial were they supposed to go forward?
there was a bench trial set, Your Honor, and everything was alive except for those things that were resolved. And what was resolved on summary judgment were counts 1, 2, and 3, and count 4 was not resolved. And they, in our position, would they be that they should have put forward any evidence at trial of count 4?
Right, counsel, you've got some time on rebuttal, and there's a lot we didn't get into on this part, but maybe we can take it up there. So now we'll hear from opposing counsel, Mr. Walter.
Good morning, Your Honor. Harold Walter here on behalf of Appellees and Cross Appellants. Let me just start off with count 4. The court, in my recollection of the record, of course will speak for itself, granted count 4, but said we're not going to have a trial on count 4 because I've granted liability on counts 1, 2, and 3, and you don't get it, both in law and equity. But the court did
there's no judgment based on count 4.
I think the court granted judgment on count 4.
Is there an order that's in the record that you can point us to that covers count 4?
There is an order in the record. I don't have it at my fingertips. But the court entered an order deciding summary judgment in March of 2021, and that order contains what the court said about count 4. And Your Honor, let me start with where I think the court started, which is the belief that both sides have taken contradictory positions in the Delaware litigation versus the Virginia litigation. And with respect, I don't think that's true. I think that appellant's counsel has done a great job of selling that idea, but it's not true. Mr. Kay's position.
Well, that may answer my general overall question in this case, which is setting aside the liability of associates on the note. Why isn't everything else that we've got the back and forth on here, maybe except for the interest, why isn't that a jury question or a bench trial question? Because it seems like you've got plenty of evidence on both sides that would cause summary judgment in the question.
I think there's several answers. One is legal and one is factual, one is practical. The legal issue is, and we cite these cases to the court, this court's rulings, the trial courts have an affirmative obligation to prevent factually unsupported claims and defenses from proceeding to trial. What they did was they took pot shots at our evidence. They didn't come forward with any evidence on their own. And the practical answer is that you have basically a bench trial. It's not going to be presented to a jury. You have cross motions for summary judgment, which means that both sides believe that there were no material facts in dispute.
Well, it seemed like to me in this situation, one important distinguishing factor between a summary judgment proceeding and a trial would be you're not going to have any credibility determinations made at summary judgment. It seemed from the surface that credibility or the lack of credibility would be a significant factor to the district court judge in making its decision.
I think, Your Honor, that what our trial court judge said was she was making judgments not based on credibility, but based on.
But she couldn't make judgments on credibility at summary judgment.
Right. So she didn't do that and didn't feel it was necessary because there was overwhelming evidence establishing the fact that Mr. Campbell understood and treated this as a loan. He reported it as a loan to the federal government on his tax returns.
But let's assume we think there's that the evidence isn't so clear. Just here, and I'm not, making that. I just want to. I'm trying to figure out practically the question I asked your colleague, and maybe this is your practical point that you just alluded to a second ago. If we think there are questions of fact about the guarantee issue and about the oral either modification or contract issue, and maybe even the equitable issue, and we were to make that decision, how does this practically work? Your colleague says you just go back for a trial, and people have bench trials all the time, just like they have jury trials all the time, and people would have to make decisions about what evidence to put in, and we would just go along on that basis. I mean, I know you want us to affirm, but assuming hypothetically we don't, do you agree with what he said about how this would go forward?
Not exactly, Your Honor, because the evidence that we would rely on is already in the record. Mr. K is not alive to testify about what he meant when he testified in Delaware. So
you may have some, practical limitations of what you can do, and you may, from your client's testimony, rely on transcripts from prior proceedings and things like that, in which case your evidence might not be much different.
right.
And it may be, the district court's rulings, I think from a practical standpoint would suggest, perhaps the district court had a view of the record now. Maybe that would be the same, maybe it wouldn't. But I mean, wouldn't the defendants be entitled to get up on the witness stand and say, if we thought there was a question of fact, I know this is what, is in the record in Delaware, but here's what was going on there, or something like that. That's what trials often happen, right?
Right. But I think that under the summary judgment standard, where the evidence has to be considered in the light most favorable to the non-moving party, the court's already done that. The court has assumed that Mr. Campbell would deny it and says, you can't deny that what Your Honor read, or I believe it was Judge Agee read the testimony where he was asked point blank, is there a note? And he says, yes, there's a note. And as I said, I think what they've done is the one piece of evidence that they have is Mr. K's testimony where he says, it's not intended as a loan. But the context of that is that in the Delaware litigation, he was talking about his motive. Why did he put $2 million at risk in a business that had no customers and no prospect of ever being able to pay it back? It's because he expected to be a partner in the business and make it succeed. I appreciate that motive issue, but let me ask you this. I read statements that the district court relied on. I think you put in about Mr. Campbell's concessions of liability in certain ways, and that's just my characterization of them. That may not be the best characterization. But what I never saw are all the terms of any oral contract. If you have an oral contract, it's got to have all the terms that make for a valid agreement. Where would I go to get the details? Not just, I have an obligation, but the details of any oral contract or any oral modification. And I don't want your words. I want JA sites if you can do that. Yes, Your Honor. So at JA 289, Mr. Campbell was asked a request to admit. He's asked to admit that he never entered into an agreement to borrow money from Richard K. He denied that, meaning he did enter into an agreement to borrow money from Mr. K.
So that you're talking about the request to admit answer.
Yes, and then the accompanying interrogatory asked him, if you deny it, explain it. And he explains it. And he says that the promissory note, he says, defendant states that he entered into an agreement to borrow money from Richard K. and or his affiliates. Defendant further states that the promissory note was drafted by K's attorneys, blah, 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 executed with with the anticipation that any additional monetary contributions from K would be subject to the same terms and conditions as the original note, as the original loan. So what you have is exactly what you, Judge Quattlebaum, what you were looking for.
So money that was loaned after the due date of a written agreement was due at the same time as the written agreement, which was before it's even loaned.
Well,
That doesn't make sense, right?
Well, it does, Your Honor. For instance, in a credit card situation where you sign up with Visa and you say, you sign a note that says, I'm going to pay you back whatever amounts of money you agree to advance to me. So 2 years after you sign the note, you go to the store and you charge something. Well, when's that money due? According to the terms of the note, it's due in 30 days. And if you don't pay it in 30 days, or if you're running a balance,
But the note doesn't say, maybe it does, correct me, you know the record a lot better than me, but my memory is the record said, you know, the note is due and payable on a specific date, not 30 days from when it's extended.
yes, Your Honor. But what the note says is that interest accrues on the running balance of the note. Running balance is not the right word, but it's that concept. It's the principal amount. So the principal amount of the note can go
It says the principal amount shall be repaid exactly 3 months after the date hereof. So does that mean under your theory that when an additional $100,000 was transferred by Mr. K after the note, that within 3 months of that transfer date, it was due?
No, it's due immediately. It's due immediately. And what that means is that you have a running balance. So for instance, if the loan,
Well, I understand that's what you say now, but it doesn't look like that's what the note says. So that was part of the dilemma on the interest question.
well, Your Honor, I think that the note does say that, you know, although the money is due in the same way that your credit card, if you're running a balance, the money is due immediately. You don't pay it. The interest starts running immediately as soon as the day you buy the item at the store. And so, you know, I think that the oral amendment is very clear that all the same terms and conditions apply. The only thing that was changed was the amount would now increase. And that's exactly what happened. So you have, you know, I think you have.
What's the evidence that your client agreed to an amendment?
The fact that he continued to loan money past the 700,000.
So the fact that money was contributed is your position is the fact that money continued to be provided by Mr. K indicates he agreed to certain repayment terms, like it's all under that same note?
Absolutely.
But did he ever say that? Is there anything in the record where Mr. K says, yeah, my understanding was these additional monies are going to be treated as a loan and repaid in accordance with the note terms?
The complaint in this lawsuit says that. And
I got that. Normally complaints aren't evidence, but I know that's maybe I hear your point there.
right. I mean, you know, unfortunately, Mr. K died days after we filed the lawsuit, so there's no testimony on that. But the fact is, as the district court said, this was either a gift and it was not treated by anybody as a gift, or it was a loan, or it was a capital contribution. We know it's not a capital contribution because Mr. Campbell opposed it as a capital contribution. And
That's not another option is that there's liability under equitable theories.
Well, there's always that as a backup, Your Honor. But I think that you have a note that is clear and definite in all of its terms. There is no ambiguity about when interest is due, how much interest is due, what the principal amount is. The court found the principal amount and found the principal amount limited to the precise dollar, to the penny, that Mr. Campbell admitted to. You know, we had a claim beyond that. The court said, not going there. And the court even denied us a trial on that issue, saying, you're not going to get a trial in federal court over $31,000. So I think the court here, you know, took the evidence waited, gave them the benefit of the doubt, and said, there is no way I could ever decide this any differently. Therefore, a trial on those issues is not necessary. Granted summary judgment. And, I think that the court did the right thing in those terms. We never got to talk really about the cross appeal, the interest issue. I think the court there was trying to do something fair, but in doing that, rewrote the contract in a way that's contrary to Virginia law and the law pretty much everywhere. The law, the interest provisions are very clear that interest began running on default. Default is a defined term. The interest should have started upon default. Instead, the court, contrary to what they say, the court did not find it to be a demand note. Instead, what the court found was that by their actions, the parties somehow changed the term. They amended the note. And as we go through in the brief and analyze it, there just isn't anything there to support that position.
Thank you, Counselor. You've both sides have reserved some rebuttal time, so now we'll go back to Mr. Kinzel.
Yes, Your Honor. Thank you. There is just no evidence at all about what these terms were going to be that were going to be agreed upon about when the interest might accrue on any advancements that happen after the October alleged due date. There's nothing in the record that supports when any oral agreement took place and what was said, what terms were done, and when the interest would due.
That was October of 2014.
2014, yes. And they describe in the brief, it's clear and unequivocal that it would be the interest would run on those other advancements from the day of the advancements. Clear and unequivocal in their brief means none. There is no evidence about that whatsoever. That is Mr. Walter in the briefs and the lawyers afterwards saying the interest should begin to run from the date that the advancement was made. But the note itself talks about 3 months from the date due, which is earlier in that year on the 7th. And so there's nothing about those terms and how they should apply. But again, it's parts of the brief, they say, well, the agreement happened right before the note was signed, when the note was signed, within days after the note was signed, and as each advancement was made, because it depends on the legal defense that's at play when they have to morph when this agreement took place. There's simply no terms. There's no, as the district court said, do you have a piece of paper, the back of a napkin, anything that shows this? They had years and years and years worth from 2014, but they wanted to do a run through Delaware for the equity transaction. When they talk about interest, I mean, it's staggering some of the things that is said in the brief, because they describe it as completely out of the blue, that the district court did this completely out of the blue. And the out of the blue stems directly from their amended complaint. And I almost could not believe it when I read it yesterday, but paragraph 19 of their amended complaint, the parties agreed to orally modify the note's due date to make the entire balance of the note due upon written demand by plaintiffs. The parties modified paragraph 22. The parties modified the terms of the note orally and by their course of conduct to include all additional funds loaned in excess of the face amount of the note and by waiving and extending the original due date. All additional funds loans would be payable in full upon demand. Paragraph 24, the note's repayment date, which remained payable upon demand. Defendants reconfirmed that the note as modified was payable upon demand by plaintiffs. That's paragraph 26 of the amended complaint. Fast forward all the years later, or a year later or so, year and a half or so, at trial, the district court said, wait, I have a trial here on the interest. How do I explain everything that took place, again, consistently with all of the facts? And the district court said interest shows from 5 days after demand was made in 2020, because they laid in wait during the Delaware litigation The Wakeshire litigation went all the way through on their claim of equity, and then only afterwards did they file in the federal court, and they deemed it as, and again, it's their scope, it's their allegation about what Mr. K's state of mind was with a team of lawyers, with the financial advisors, what was the terms of this note, and they said they orally and by course of conduct, made it a demand upon demand note. And the district court's ruling is exactly what they said it was, but they don't like that now because they already locked in the principal amount. So at trial, they had a different position. To deem it completely out of the blue is it's incredible. And also the court's ruling is very consistent with what took place at trial. Again, they have a quote that the law doesn't favor technicalities, that it favors trial on the merits, their quote and their brief, but it's on the interest. There was a trial on the merits. That's what the law favors. They don't use that quote in the summary judgment part of it because that's not a trial on the merits. That is weighing credibility is what did occur here, because if you can't get to the result that the district court did without weighing credibility, because if the note and the concept of a loan is deemed totally untrue, the very existence of a loan is totally untrue, light most favorable to the non-moving party, then there is no note, there's no loan, there's no liability. And so at trial, there was the statements made in the complaint and the amended complaint. No objection to that coming in by the plaintiffs and the appellees. There was a demand letter itself. There was a note that has upon demand in it. There is the impossibility, as the court pointed out, of how interest would be applied retroactively for future advancements. To deem this like a credit card is woefully different than what a note is for a fixed sum. No payments ever were recognized by the appellees. They talk about the tax returns and the payable reports. They say, well, sloppy record keeping shouldn't go against us. But those sloppy records are what they use as admissions. And so, as it hasn't come up in oral argument, but in the Delaware litigation, the reason why they had the payable reports is because of their claim for equity. And Mr. Walter and his law firm reviewed those payable reports. Well, those payable reports are not ticking up based upon interest. They're fairly constant. There's some deviations of 2,000 for the mathematical error, but they don't tick up in interest. There's no objection. Hey, where's the interest? Why isn't interest accumulating? So that's another piece of evidence here. No demand for the money ever occurred during the Delaware litigation. And there's never any kind of objection or statement for them to ask for it. So the court, I know my time is about up, but when we go to the bottom line, as the court mentioned in the prior argument, there really was a credibility determination, and the summary judgment ruling is inconsistent with Rule 56, and the interest at trial on the merit should be sustained. Thank you.
Thank you, Mr. Kinsel. Mr. Walter.
Your Honor, the language in the note couldn't be clearer. Under interest rate, it says commencing on the date of default of this promissory note and thereafter until all sums due and owing hereunder shall have been paid in full, interest shall accrue on the unpaid principal amount at the rate of 6% per annum. So you have a very clear statement in the note that you have a 90-day interest-free period after which interest begins to run.
What's your position, counsel, on that your complaint says something different? You came into court and said, we agreed to change that. That's one thing that I asked you about the terms earlier, where I find specific terms. And you said, well, the complaint counts. Here's a complaint where you allege there'd been a modification of when the interest is due.
Right.
We supposed to just use the complaint when it helps you, but not when it hurts you?
No, Your Honor. We use the complaint when those claims made in the complaint are pursued and relied upon by the court. And in this case, what happened was that claim was unproven and abandoned. Nobody relied on it. And the district court went through and said, I'm not going to hold you to that because it's not a judicial admission. Nobody relied on it. And in the brief, we go through in greater detail that I'm going to have time to do today, what you need to show, what courts in this circuit have said is necessary in order to hold someone to an unproven allegation in a complaint. You know, so I guess one of the things that I just heard counsel say is that Mr. K laid in wait as if somehow this is, you know, getting interest on his $2 million for the 6+ years that Mr. Campbell kept it is somehow unfair. The parties agreed that the interest rate would be 6% per annum. Mr. Campbell kept the $2 million the entire time. He could have paid it back at any time. He could have put it into, if you know, his argument is you wouldn't have accepted it. If that were true, he could have paid it into the court. But the fact is he kept the money and he used it. And the parties agreed that the value of keeping that money was 6% per annum. So it's not appropriate for a court to go back and say, well, 6 years is a long time to keep, you know, to run interest. It is a long time, but it's also a long time for him to keep the money, which he did voluntarily. So, you know, when we talk about what's fair, which as we all know is not always what the law does, but it is a consideration. It's certainly not unfair. And it was the expectation of the parties that for so long as he kept the money, he was going to pay 6%. And there is nothing, absolutely nothing in the record to indicate that Mr. K ever said, well, I'm going to go to Delaware and pursue the equity deal, the transaction documents. And while I'm doing that, you can keep the money interest-free. The only discussion of interest-free was the first 90 days. So, you know, I think in terms of interest, the court, you know, was trying to split the baby and fashion something that it invented. The other thing is to keep in mind that Mr. Campbell has not, I mean, Mr. Campbell stands up and says, I didn't know anything. I don't owe the money at all. And I don't owe any interest. So his, you know, latching on at this point to the court's analysis is inconsistent with his position. So, you know, I think if we look at Mr. Kinzel mentioned the fact that the demand note also that the promissory note also includes the word demand. And as we went through with the district court and in our brief, that is simply an editing mistake on the part of both counsel. Mr. Campbell objected to this being a demand note and insisted that it be a time note. Mr. K agreed with that and instructed both clients instructed the lawyers to remove all of the demand language. The lawyers did that as best they could, but they missed one word in the introductory paragraph. Mr. Campbell reviewed the note, believing that it was now a time note. He also missed the one word. Now he wants to latch onto that one word to create ambiguity. I don't think it creates ambiguity because, as this court knows, when you have a specific provision that deals with something, it takes precedence over a general provision. You have the specific provision that I just read, which provides when interest began to run, and it's based on time, not on demand. And then taking into account the court's position, the district court's position, that in order to, you know, for course of conduct to modify the contract, the party asserting it has to prove mutual assent in either the passage of valuable consideration, estoppel in pay, or waiver. We go through in our brief in great detail all of those things. There's clearly none of those have been established. There's no mutual intent. Mr. Campbell still stands up and says, I don't know anything. So he certainly didn't agree to a suspension of interest. There was no valuable consideration, no estoppel, and certainly no waiver. Waiver is an intentional relinquishment of a known right. Mr. K never relinquished interest. He was asked no question about it. He gave no answer about it. And so, Your Honor, I think, from the standpoint of interest, the court's ruling was out of the blue and was inappropriate and should be reversed. In terms of, going back to the main issue, I don't think there would be any purpose served in having a bench trial when the issues that were decided by the court. I think the court, as I said before, gave Mr. Campbell the benefit of the doubt, assumed that he would testify, that he didn't mean it, although and again, there's good case law that says you can't create an issue in summary judgment by filing an affidavit that contradicts your prior testimony or statements without explaining how those statements were wrong or misleading. He's had that opportunity. He's never come forward and explained why they're wrong. And so essentially you have a party who says, I got $2 million and I should never have to repay it. And I think that's where this case lies.
All right, thank you very much, Mr.
Thank you.
Walter. For the first time in some time, we're now going to be able to come down and greet counsel. Show our appreciation for your arguments. I know this has been a long controversy for the parties, and they have a lot invested in it financially and emotionally, but it's not too late to reach a settlement in this case. One party or the other may come to find in the future they'll regret it if they didn't take that opportunity. So with that, we'll come down and greet counsel. Sela versus Garland. Mr. Slack, whenever you're ready to go, be glad to hear from you.
Thank you, Your Honor. May it please the court. Ben Winograd, representing the petitioner. The primary issue in this
My
case.
mistake. Sorry, Mr. Winograd.
No, great. The primary issue in this case is whether non-citizens whose grants of asylum have been terminated remain eligible to adjust status under 8 U.S.C. 1159B. We asked this court to join the Fifth Circuit in holding under the first step of Chevron that such former asylees remain eligible to adjust under that provision. But even if the court finds the intent of Congress unclear, we ask it to not defer to the board's decision in this case under Chevron or Skidmore. And if the court does rule in our favor, we ask it to order the government to facilitate my client's return to the United States for the continuation of his removal proceedings. Now, at the outset, if the court has any questions about the government's mootness argument, I would be happy to answer them. Otherwise, I will turn to the merits. The underlying premise of the board's decision was that the phrase, the status of any alien granted asylum, refers only to current asylees. And if that phrase existed in a vacuum, there might be some force to that argument. But that phrase does not exist in a vacuum. And language in 3 surrounding provisions strongly suggests that Congress did not intend that phrase to mean what the board said it means. The first is 1159A, which is the provision that allows refugees to adjust to LPR status. Congress listed 3 requirements for refugees to adjust status, the very first of which is that their admission, quote, has not been terminated. Because Congress expressly prohibited former refugees from adjusting status, but did not expressly prohibit former asylees from adjusting status, there is a strong negative implication that Congress did not intend to prevent former asylees from adjusting status.
Counsel, what's your best guess as to why Congress would have done that, treated the refugees different from, well, people with who once had refugee status, different from people who once had asylum status?
Sure, there is no legislative history on that point, but I would note that the grounds for termination of asylum status are much broader than the grounds of termination of refugee status. The only way refugee status can be terminated is if the non-citizen was not a refugee at the time of admission. In other words, they were admitted based on fraud. So in that scenario, perhaps Congress thought to make clear that someone who was not a refugee in the first place clearly should not be allowed to adjust based on their refugee status.
Am I reading, I don't have any experience with 1159A, but am I reading it right? It sounds like what for refugees, unless your status has been terminated, if you are admissible, like that's it, they're going to adjust your status, that it's not a discretionary determination, or is it still discretionary?
I am not certain about that myself, Your Honor. Typically with adjustment of status, there is a discretionary component. But although this particular statute does not say may, so I am not certain about that.
So can I
Yes.
ask a question? And this is, I think in response to what you said in your introduction, that even if we consider the statute ambiguous, you ask us not to defer under either Chevron or Skidmore. And I'm trying to make sure I understand what if we do find it's ambiguous, how should we go about interpreting the ambiguity? What's your position on that?
Sure. Well, our position is that if the court finds the intent of Congress unclear, the board's decision is unreasonable for Chevron purposes because the scheme that it creates is arbitrary and capricious. So as a result of this decision, whether a non-citizen can apply for adjustment depends not on whether his grant of asylum is actually amenable to termination, but simply on when an IJ happens to decide the government's request to terminate asylum. So in some cases, such as this case, the IJ will terminate asylum at the outset of the proceedings, and thereby preventing the non-citizen from adjusting status. In other cases, the IJ will simply defer the request, thereby allowing the non-citizen to apply for adjustment of status. So under this approach,
if we've concluded that the statute is ambiguous and we're not according any deference to the agency, how are we to resolve the case?
sure, I think there are two possible ways. One is that the court could simply interpret the statute based on what it thinks is the best interpretation. But acknowledging that under Brand X, the board might be free to reach a different conclusion if it takes into account any reasons that this court declined to afford Chevron deference. Alternatively, the court could simply remand for further consideration by the agency itself. So I think it would depend on the reason the court declined to defer under Chevron.
Can I ask
yes.
you a question about your Chevron step 2 argument? So
Yes.
if you're right, and just assuming, I guess, hypothetically that, that would be sort of an arbitrary result, why isn't that something we can look at under Chevron step 1? Like, don't we normally, in construing a statute, try to avoid random and arbitrary results? Why is that a step 2 issue, but not a step 1 issue?
Well, we framed it as a step 2 issue because under the assumption that the intent of Congress was not clear.
But under step 1, it seems like the Supreme Court more and more is telling us like bring out the whole toolbox on step 1 before you call something ambiguous. Like, you should try everything to figure out what the best meaning is or what the proper meaning is. And I don't see why, as part of that toolbox, sort of avoidance of arbitrary results wouldn't count. I understand your argument at step 2. It seems to me that some of what this case is about is how much we're supposed to do at step 1 these days. So I guess maybe instead of why don't you tell me what you think we can do under step 1 before we get into this whole step 2 issue?
Well, yes, I think certainly the court could try avoid an arbitrary result under step 1 because presumably Congress does not like to reach arbitrary results. So, but I think under step one, the court would need to look at not simply the language of the prefatory clause of 1159B as the board did, but the surrounding provisions. So I already spoke about 1159A1. Another provision the court could look at is the note to section 1159 that Congress enacted as part of as part of the Immigration Act of 1990. That provision applied to non-citizens who had been granted asylum, but who no longer qualified as refugees because of changed circumstances in their native country. And in a parenthetical, Congress confirmed that such non-citizens could adjust status under 1159B, quote, regardless of whether or not their asylum has been terminated. So by specifically authorizing former asylees whose grants of asylum had been terminated to adjust status, Congress necessarily believed that they qualified as aliens granted asylum. Now, the board did not discuss this provision.
1159B2 uses language I think you already talked about that would seem to argue the other way. That's a statute, not a note.
Yeah, well, we rely on section 1159B2 because 1159B2 uses the phrase granted asylum in a way that the parties agree refers to a historical event. It says to qualify for adjustment, a non-citizen must, quote, be physically present in the United States for at least 1 year after being granted asylum. So the parties agree that that refers to a historical event. And we think it would have been odd for Congress to use the phrase granted asylum 2 times in the same statute to mean 2 separate things.
So why would we record any weight to the Fifth Circuit's decision in Seaway?
Yes, well, we asked the court to join the Fifth Circuit's decision in Seaway. That is,
they didn't have the benefit of a precedential decision at that time, or the Supreme Court's decision in Henson that dealt with granted in 1159B as both a past tense verb and an adjective. That would seem to be 2 very significant differences. I don't think they discussed the term status in that case either.
they didn't. Well, a few responses, Your Honor. One, Seaway was a Chevron step 1 case, so it wouldn't have mattered whether there had been a precedential board decision in that case. 2, I think the Supreme Court's observation in Henson, it may not have been dictated in that case, but I don't know that the language that Your Honor is referring to in Henson is not really a novel concept from a grammatical standpoint. I don't think that's something that would have been news to the panel that decided Seaway. And then I forgot Your Honor's 3rd point.
Not sure they ever discussed the meaning of
status. Yes.
Say as our panel did, I think, in Lockwood.
Yes, thank you, Your Honor. It is true that Seaway did not discuss status, but I think the board over-relied on that term. The board assumed that the phrase status necessarily refers to a positive or lawful status. But both the Ninth Circuit and the Fifth Circuit have held in other cases, which we cite in our brief, that the phrase status can also refer to unlawful status. And I would also point the court to what is the adjustment provision, the general adjustment provision for all non-citizens. It's 8 U.S.C. 1255A. And that provision says the status of an alien who was inspected and admitted or paroled into the United States may be adjusted by the Attorney General to that of an alien lawfully admitted for permanent residence. Now, a plurality, if not majority, of non-citizens who adjust status under that provision have no lawful status. They came in on a temporary visa, overstayed that visa, and then married a U.S. citizen, and who then was able to sponsor them for permanent residence. But they are overstays. They have no lawful status, and yet Congress used the term status in this adjustment provision.
Counsel, can I ask you a question? And it goes back to what you told Judge Agee about B2 and after being granted asylum. That's like a past tense use of granted. So if any alien granted asylum in that opening phrase is using granted as a past tense verb, it refers to having been granted asylum in the past, then why doesn't it follow, and this would be, I'm bringing you to our Mahmoud case, that a non-citizen is still an alien granted asylum after he or she adjusts to LPR status, because they were granted asylum in the past.
Sure. Well, I think Mahmoud itself distinguished that on those terms. It did not involve non-citizens who were whose asylum status was involuntarily terminated. It involved those who voluntarily relinquished their asylum status, and it made clear that the two are not the same.
Yeah, I understand that you
Yes.
can try to distinguish that, but I guess let me ask the question this way.
Yeah.
So what is your definition? What definition should we adopt of any alien granted asylum as it is used in that phrase? If it can't mean, you think it doesn't mean currently granted asylum, and we know it can't mean ever granted asylum in the past, because that would sweep in someone who had now become an LPR. So what does it mean?
We think it means granted asylum in the past, so long it has not been relinquished in favor of another status. And
It's a funny way to say that, right?
well, I would note that the Fifth Circuit does not regard these positions as mutually exclusive. So in Seaway, as we discussed, the Fifth Circuit adopted our position on the question at issue in this case. But Seaway did not prevent the Fifth Circuit from later adopting the government's position in Mahmoud when it decided Ali versus Barr in 2020. And although she did not write either opinion, I would note that Judge Jones was on the panel that decided both Seaway and Barr. So just as the Fifth Circuit did not regard Seaway as precluding its subsequent holding in Ali, nor does Mahmoud prevent this court from adopting our position at issue in this case.
I thought, didn't Seaway itself, I thought Seaway actually sort of addressed this issue, because weren't they were distinguishing a Ninth Circuit case that had, it doesn't matter. Sorry, go on.
They did, yes,
I'm too in the weeds. Yeah, you go.
Yes, no, they did distinguish the Ninth Circuit case that Your Honor is referring to, but the point is that the panel that decided Ali subsequently did not view the positions as mutually exclusive. And I think a hypothetical may help demonstrate why those issues are distinct. So imagine the Democratic National Committee adopted an edict for all campaigns that they could only hire workers who had quote, registered as a member of the Democratic Party. Now, a person who had once registered as a Democrat, but later switched their registration to Republican, clearly could not be hired under this policy. But I don't think it necessarily follows that someone who once registered as a Democrat, but then had their name stricken from the voter rolls because they were convicted of a crime, could not be hired under this policy. I think it would simply be a different question presenting different concerns. And so the same logic applies here. Even if a non-citizen who would just from asylee to LPR status no longer qualifies as an alien granted asylum, it doesn't necessarily follow that a non-citizen whose asylum status was involuntarily terminated no longer qualifies as an alien granted asylum. So again, we think this court's decision in Mahmoud is simply distinguishable. I'll reserve the remainder of my time for rebuttal. Thank you.
All right. Thank you, Mr. Winograd. Ms. Slack, we'll now hear from you.
Good morning. May it please the court. Michelle Slack on behalf of the Attorney General, Merrick Garland. Petitioner is seeking ultimately to adjust his status under a special provision that is for non-citizens who have been granted asylum. And he suffers from two defects in that regard as we move forward in this case. The first defect is the one that Petitioner's Counsel has addressed, the issue of statutory construction that we find in the board's published decision in matter of TCA. The other reason that he suffers from a defect or defects is because of his post-decision, post-pending petition, departure from the United States and return to Albania. Now, I set these arguments out in the other order in my brief, but unless the court has any questions, I'd like to address them in the order in which I just set out. First, the matter of TCA issue of statutory interpretation, then moving to the issue of the departure and what effects that has on his eligibility for adjustment asylum. First, the issue that is in play here is the question. You have a special type of adjustment that Congress has created for asylees found in 1159B. You have someone whose grant of asylum was terminated. And now you have to ask yourself whether or not the terms, the status of any alien granted asylum means he's still been granted asylum when that grant of asylum has been terminated. And that brings us to a question first of Chevron deference. And we would start the question with Chevron deference with step 0, as administrative law experts refer to it. And that's the question of, is Chevron applicable? And we have a published board decision here, much like there was in the case of Mahmoud, in which the board addresses this specific question in matter of TCA. We also have reference within TCA to the regulations that are the sole and exclusive procedure for adjustment of status under 1159B
What would your answer be to the question that Judge Harris asked opposing counsel? The Supreme Court now seems to be on a direction that says before you determine something that's ambiguous and start to look at the Chevron factors, you need to try everything you can possibly do to find the correct meaning for this that Congress intended, no matter how contradictory, confusing, and totally messed up the statute may be. So are we relieved of that duty in this case?
No, Your Honor. In fact, I haven't gotten to step 2 yet. I would first start with Your Honor by saying that that at Chevron step 0, we clearly have the application of the Chevron process. So we would then move to step 1, and I think that's the nature of your question, and was the nature of Judge Harris's question as well. And it would start by looking at whether or not Congress has dealt with this precise issue. Then we would move, as the Supreme Court has cautioned, to the whole spectrum of ways
Counsel, can I, since we're at the whole spectrum, I will just tell you, this is my concern, I guess, from your perspective. This is the biggest question I have with sort of reading this as ambiguous. We can assume, or I will assume hypothetically, that if you look at this phrase in isolation, it doesn't speak clearly to this question. But the thing about this statute that seems sort of striking to me is how many times where Congress meant you have to have the relevant factor has to be present at the time you apply for adjustment. It said so. It said so in 3, you have to continue to be a refugee. It said so in 5, you have to be admissible at the time of examination for adjustment. So when it doesn't say that, in the prefatory phrase or anywhere else about your asylum status, it's like the one thing it doesn't say has to be current at the time you apply for adjustment. Why isn't that extremely good evidence that Congress didn't mean it? Like, it could have just put in the same language it has in 5 at the time of examination for adjustment. It could have just put that right in, the status of any alien granted asylum at the time of examination for adjustment, but it didn't put it in.
Your Honor, I have a number of responses to that. I'll start with perhaps because the very definition of asylee status that we find in 1158C1 defines asylee status as the status of an alien granted asylum. So they may have felt that it would be unnecessary and redundant. So now I'm going to describe that means it has to be current.
But you could say that the alien was granted asylum. It's true as a historical fact, but they don't have that status now. So does that necessarily support your argument?
Well, Your Honor, with all due respect, the statute doesn't say was granted asylum. It says any alien granted asylum. And that's part of the reason why the board said this is like the situation in Henson. And the term granted is being used as a past participle adjective to describe the word that follows it. Like the court said in Henson, like burnt toast is inedible. A fallen branch, a fallen rock blocks the path. Or if this court has a rule that admitted attorneys maybe appear before the court, but I know I was disbarred last week, and I'm saying, well, I was admitted at one time, and since the rule is a historical event, I don't have to worry about the fact that I'm no longer admitted to the bar. So that's the kind of interplay that we have here. So the terms granted asylum, and then granted asylum would have really no meaning if it wasn't a present state of something, as it's used in the provision having to do with termination. I mean, you're really looking at not just this provision in isolation, as the Supreme Court suggested. You have to look at it in context as well to try to see if there's an ambiguity or if you can resolve the ambiguity by looking at it in context. And if you look at it in context, the expression you find in the termination provision at 1158 C2 speaks of an alien granted asylum cannot be removed until asylee status has been terminated. It also uses that phrase, granted asylum. And so how could you have that asylee status terminated if in fact you go back to C1 and that person still enjoys all the benefits of a person granted asylum because it's based on a historical event? So returning to Judge Harris's question about why didn't they just say it? They could have also used the phrase that is relied upon by petitioner that comes from the 1990 Act, the note to the 1990 Act, which creates a special exception for former asylees, where they put in a parenthetical right after was granted asylum, regardless of termination. They didn't do that either. And so there, along those lines, there's also a very big difference between, the third reason that they probably didn't think they needed to in 1980 when they promulgated the Refugee Act is like refugee termination. The only form of termination that existed in the immigration laws for asylum was you were no longer a refugee. So that is similar to the provision we find in 1159A of the consequences of termination of refugee status is like the continuity provision we find in 1159B3 in that regard. If you could only be terminated at the time for no longer being a refugee, well, there would be no need, again, somewhat redundant, to add it to the prefatory language we find and that we're discussing here today. So basically 3 reasons. The first is we have that expression granted asylum elsewhere and Congress understood it to mean something. And then 2, that you have a companion place where the fact that they could only terminate based on no longer being a refugee, well, that's already incorporated in B3. And I plumb forgot the third reason, I'm sorry. And as the court has suggested, so going back to whether or not we have an ambiguity, the Congress has not spoken directly on this issue in the context of just looking at, in isolation, this phrase, status of any alien granted asylum. We know that because we look at, as counsel for petitioners pointed out, we look at 1159 A, and we see a clear statement of the consequences of termination. All right. On the other side, we look at the note that is in the 1990 Act that says, regardless of termination. The phrase that a petitioner wants to read into the statute, but isn't there. What we have on both sides are different ways that Congress could have done this to make it very clear on this precise question. Congress chose neither, and we're left in the middle. And then what it's incumbent on the court to do then is to not just walk away and say, oh, we've got an ambiguous statute. No, the Supreme Court has said you have to go on that deeper dive. And you have to look at all the canons, the full spectrum that's available to you, the surrounding provisions. Some of the arguments already made about the surrounding provisions. You look to statutory construction tools. And that has to do with the nature of the terms chosen there, the granted asylum and the fact that it's been used elsewhere in the statute, that granted asylum, it wouldn't be used as a past tense verb in this manner. If it was used as a past tense verb in this manner, you would need the helping verb that was referenced before. You'd need the was, because clearly the alien is not granting himself asylum. He's the object. So you would need some type of passive voice for this to work the way the petitioner alleges that it works. In addition to that, you have the importance of the term status here. And that ordinarily status does refer to a lawful status. It doesn't mean it always has to refer to a lawful status. But ordinarily it's known to refer to a lawful status.
Counsel,
And status,
can I just so I understand where you are, where we are in
Okay.
the Chevron boxes. You're under step one and you're suggesting,
Mhm.
and I agree,
Yes.
we have to do all of this work under one. When it's all done, is it the government's position that this is a Chevron step one case and unambiguous? We can say that unambiguously, when we look at everything, we use all of our tools, the answer is clear, like you have to have current asylee status. Or is it the government's position that even when we're finished with all of that, we're in step two and we should defer to the BIA?
I think that the court could find that, as I'm pointing out, what appears to create an ambiguity or appears to suggest petitioner's reading is and the Fifth Circuit's reading is correct. These are all reasons why it's either ambiguous or it's clearly the other way.
Well, but I guess I'm asking you which. Does the government, the government should have a position on which.
No, I mean, I'm saying that the better reading
Okay.
is and that's the way it's argued in the brief, is the better
I couldn't
reading.
tell from the brief. So your answer is this is a step one case. The right reading is that you need current asylee status. You don't need to bring that deference.
And that if the court disagrees about that.
I'm going to just stick you on one. So you think this is not a deference question. We're not deferring to the BIA. We are just deciding under step one that this is the right reading of the statute.
I think that's the better reading, Your Honor. But if the court disagrees and finds it ambiguous, then it's at least ambiguous. I mean, I should say at worst ambiguous. And such that the board's
So in step one, we would disagree with the Fifth Circuit.
yes, Your Honor. And there are a number of reasons why you should not follow the Fifth Circuit. And the Fifth Circuit's decision is not persuasive. And if you would like, I can explain those to you, Your Honor. First of all, as you pointed out, the Siway case did not have the benefit of a board decision, a published board decision that's thoroughly examining this issue. Okay. In fact, that's a big part of the reasoning.
Right, but if the statute's not ambiguous, why would we need to even look at the BIA decision?
Because they didn't have the benefit of all these arguments on the clarity of the language, the how to resolve any ambiguities if you see them. There were no arguments made in the government's briefs in Siway. They didn't have the benefit of these arguments.
There were no arguments made in the government's brief.
There were no arguments made about the ambiguity or lack of ambiguity in the statute. In fact, the government's arguments rely on what the board relied on in Siway, which was that the board considered it already settled by prior precedent of the board. And what a big part of the reasoning in Siway is that this prior board precedent really doesn't inform the issue at hand. It's also why they distinguish the other cases that they're discussing in Siway. I mean, the first time this issue is actually raised is in Siway. And so the court correctly recognized it was the first time it was raised, but the government made no other arguments about the statutory interpretation or any ambiguity in the Siway case. So they didn't have the benefit of that. So they can't be faulted for not having a particularly persuasive viewpoint. I'd also point out that in Ali 2, the Fifth Circuit faced the same issue this course faced in Mahmoud, okay, which is the flip side of the coin. All right. In this case, we're looking at what are the consequences of termination on adjustment. And in Mahmoud and in Ali 2, the courts were looking at what are the consequences of termination on adjustment question. And because these issues interrelate to one another, the court is again looking at the interplay between 1158C and 1159B. And because the court in Mahmoud has already concluded, like the court in Ali, that that you lose the status of being a alien who'd been granted an alien granted asylum when you change status or you adjust status to lawful permanent residency. Because the court's already concluded that, it's already necessarily concluded that's not a historical event. Because
But the Fifth Circuit did address that, although it itself had not yet reached that question. The Ninth Circuit had, and it said that's a different question. And it explained, I mean, we don't have to follow the Fifth Circuit, and you can think the Fifth Circuit was wrong, but I just don't think that this was the sort of unexamined opinion you're suggesting it was. And they they confronted the Ninth Circuit's version of our Mahmoud decision and said that is just a different thing.
Yeah, and said it's a different thing. And the court in Ali 2, that after the court in Ali 1 sends it back to the board to render a published decision on the precise issue. And when it comes back on Ali 2, the court makes no reference to Siway.
That's because it already explained they're two different questions. I mean, I feel like it sort of did that work the first time, but it doesn't matter. I don't want to get you hung up in this.
But a big part of the Siway decision was this difference between the language you find in 1159A and the language you find in 1159B. All right. And can I address that difference and why it's important? Because I do think it's perhaps the strongest argument petitioner makes. And it was primary basis of the Siway decision.
In a succinct way, because your time has.
Yes, I see. These are two different, they're not parallel provisions. You look at them and they don't describe the same type of process. Under 1159A, what you see is someone is admitted as a refugee. And then that's a conditional admission. And then they come back before the Department of Homeland Security and their admission is converted into lawful permanent residency. The only reference to status in the A provision is a reference to you couldn't previously have been a lawful permanent resident. If you look at the B section for asylum, it's clearly a switching of one status to another status. That is an explanation for why you wouldn't have necessarily had to put the consequence of one thing in another thing. It's looking back at the original admission in A, and it's part of the continuous refugee process in B3. And those two provisions are working very differently from one another. If there are no further questions.
Thank you very much, counsel.
Thank you.
Mr. Winograd, you've got some rebuttal time.
Thank you, Your Honor. The government now claims that this is a Chevron step one case. I don't know whether the Chenery Doctrine precludes the government from switching what Chevron box they're in, but I would simply note that even the board itself did not think that its position was compelled by the clear intent of Congress, and its analysis relied on tools that can't be considered at step one, such as its own precedent that postdated the statute and of which Congress could not have been aware. The government also notes the lack of an auxiliary verb in the phrase alien granted asylum. I would say Congress, like people, sometimes omit auxiliary verbs when they're speaking. So if I were to say, today I appeared before 3 judges asking questions, that would mean the same thing as I appeared before 3 judges who were asking questions. Sometimes it's a matter of simple diction, we omit auxiliary verbs like that. Now, if the court goes to the second step of Chevron, I just want to emphasize exactly why we think the scheme that results from the board's decision is arbitrary and capricious. As I was saying before, whether an asylee whose status has been terminated is allowed to adjust depends solely on timing, on whether the IJ considers the request for termination at the start of the hearing or on whether they agree to defer it until the end of the hearing. The Supreme Court said in Judelang versus Holder that if an IJ were to determine a non-citizen's eligibility for relief by flipping a coin, they would reverse that policy in an instant. But that is in effect what the board has done here. Some asylees who have been convicted of an aggravated felony will be able to apply for adjustment of status, while others will not be able to apply for adjustment of status. And the only guidance that the board has provided as to why that may be is that IJs may defer ruling on a request for termination if the non-citizen is deserving of adjustment of status. But that's really no guidance at all, because IJs cannot determine whether a non-citizen is deserving of adjustment of status unless they're allowed to apply and put forth evidence in support of their application for adjustment of status. And we think this scheme is particularly unreasonable because there is a far more sensible alternative. As we conceded in our brief, IJs should always consider whether to terminate asylum at the outset of the hearing, because if they don't terminate asylum, there's no need to have removal proceedings in the first place. The person is not subject to removal. But it doesn't follow that once a grant of asylum has been terminated, the non-citizen should no longer be allowed to apply for adjustment of status. Given that the board has allowed IJs for decades to consider adjustment applications of non-citizens whose grant of asylum could be terminated, we see no principled reason why it couldn't also allow IJs to consider adjustment applications of non-citizens whose grants of asylum have been terminated. And if the board declines to afford Chevron deference, we think it would follow that it should also decline to afford a Skidmore deference. As I noted before, the board itself did not acknowledge at all Section 104 of the Immigration Act of 1990. And as we discussed in our briefs, it didn't acknowledge that USCIS takes the same position that we take in its policy manual.
Counsel, can I ask you a question about the statutory note and the regardless of whether asylum has been terminated? So I am, I read the briefs in the order I get them. I read your brief, I looked it up. I was like, wow, great argument. And then I read the government's brief and I looked at the exact same thing. And I was like, oh yes, very good argument. I mean, this one I find really challenging. I mean, on the one hand, the government says when Congress meant, regardless of whether it's been terminated, it says so. On the other hand, how would you respond to that? I don't want to say your argument for you. What's your argument for why is that not the right way to look at that?
I think it's because of the placement of the proviso in question. Had Congress started that section with that proviso, for example, by saying, if it started Section D by saying, regardless of whether or not such asylum has been terminated under Section 208B of the Act, the provisions of Section 209B shall also apply to an alien who X, Y, and Z. In that case, it would very clearly serve as a notwithstanding or but-for clause. But the way they tuck it in offhandedly into a parenthetical, in my reading, makes it seem as though Congress was legislating against a background assumption that non-citizens whose grants of asylum could be terminated remained eligible for asylum and were, in other words, aliens granted asylum.
Okay, Because it's in a parenthetical, like, yeah, everybody knows it, but we just want to be clear.
Yes, kind of a belt and suspenders approach,
Okay.
if you will.
Okay.
Thank you, Your Honors.
All right, thank you all. We appreciate the arguments of both counsel, and we'll come down and greet you, and I'll ask the clerk if she will adjourn court until tomorrow morning.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.